David Fowler here, and I wanted to give you a quick understanding of some of the major issues associated with a decision that was just released by the Fourth Circuit Court of Appeals dealing with the bathroom bill issue and Title IX. It's the case of G.G. versus Gloucester County School System. It was a case in Virginia. And the school system won their lawsuit originally, saying that the Title IX allows for the segregation of bathrooms according to biological sex. The Fourth Circuit Court of Appeals reversed that decision, sent it back to the trial court, but you need to understand what the Fourth Circuit did and how our courts are literally rewriting laws. And to be honest, Congress is going to have to start doing something with judges who rewrite their laws. So, follow along on this little slideshow. It'll give you, I hope, a great picture of what the court has actually done and how they have rewritten the federal law.
So how are we to understand this ruling on Title IX? Well, we have to appreciate that Title IX says no person shall, on the basis of sex being the key word, be subjected to discrimination under any education program or activity receiving federal financial assistance. Well, what does the word sex mean? Well, there are only three choices based on the arguments that are being made. The word sex means male or female. It means instead gender identity. Or it means male or female and gender identity. But what's the problem here? Let's take a look at the slide we just showed. Male or female is quite understandable and everybody knows what that means, but if you go with the idea that the word sex means gender identity, look what the court has done. It has substituted a new word for the word sex. That is judicial rewriting of the law. Well, let's take a look at the possibility that what the court means is male or female and gender identity. Well, consider what the court has done then. It has added a new term to go with the term sex. That, too, is the judicial rewriting of a statute. But now here is the problem. It rewrites the law when you begin to substitute words or add new words. That's judicial activism at its worst and plainest. Now, let's take a look at what the court also acknowledged. The department's regulations implementing Title IX permit the provision of separate toilet, locker room, and shower facilities on the basis of sex. So going back to what we've just said, if you eliminate the word sex and say, well, that word really just means gender identity, well, now what do we have? We have a problem. This particular court case was limited to a case involving the toilet. But the statute isn't just limited to toilets that are separated by gender identity, but includes the notion of locker rooms and showers. So you can't separate the word gender identity out and say that it only applies to toilets without saying it also applies to locker rooms and showers. And that opens the door to the very kind of perversions that we have talked about in connection with House Bill 2414.
So what's next? Well, we understand that there may be a request that the entire Fourth Circuit hear the appeal rather than leave it with just these three judges who split on their decision. We won't know about that for a while. But if the whole court hears the case, then the whole court can change the outcome of the decision that was just issued. What does this mean for Tennessee? What does it mean for our bathroom bill? Does it mean that it's good that our bathroom bill did not pass? No, I don't think that means that at all. Because really, here is the decision that our legislators must now face. We must either decide we are going to live under the Fourth Circuit's ruling, assuming the ruling remains the same, or we're going to say, no, we live in the Sixth Circuit. We live in a different circuit. We're not governed by the Fourth Circuit, and we're not going to allow the Fourth Circuit to determine what we do in Tennessee in the Sixth Circuit. We have the opportunity next year, I hope, to pass a law and say to our circuit, which is more conservative than the Fourth Circuit, that our understanding of Title IX is actually correct. So by no means does this Fourth Circuit decision mean that the issue is settled for Tennessee unless we're willing to to live with a ruling from another circuit that's not binding on the state of Tennessee. So stay tuned for more and be ready for action.